Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Court, now sitting at Boston within for the Commonwealth. Join in, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please receive.
Good morning and welcome to the Appeals Court. I'm Justice Peter Sachs. To my right is Justice Marguerite Grant. To my left, Justice Paul Hart-Smith will be your panel for the first 4 cases today. There will be a panel change for the final case. As you know, if you've been to the Appeals Court, there are 15 minutes per side. We have no rebuttal. The yellow light will go on when you have 90 seconds remaining in your argument. We are quite familiar with your arguments and with the record in each case, so I would urge everyone to get right to the heart of your argument. And with that, I will call the first case, which is 22P1189, Commonwealth versus Jacob Scott. Mr. Maddox.
Good morning, Your Honors. My name is John Maddox for the defendant Jacob Scott. Mr. Scott objects to 2 remarks in the prosecutor's closing argument. One was that he was not being charged with resisting arrest when he was stiffening his hands during being handcuffed. The second statement, the second remark was a misstatement of the evidence by characterizing one of Mr. Scott's statements as a denial of having anything to drink. That was an unfair inference, I'm suggesting. In regard to the first remark, the statement of not being charged with resisting to arrest, it suggests that the Commonwealth could have charged him with an additional crime, and I'm suggesting it's a type of uncharged...
Didn't the jury know from the verdict slips and the reading of the complaint that the defendant wasn't charged with resisting arrest?
He was not charged with resisting arrest.
Correct, and the jury already knew that, didn't they, from the verdict slips and the reading of the...
Well, they would have known that from the jury, that he was certainly not charged with it, but he could have been, is the suggestion. That's the implication. And it's pointing out to the jury that the conduct of stiffening your arms while being handcuffed is the crime of resisting arrest in and of itself. So it's not just a factor to be weighed in determining OUI impairment. It's a crime in and of itself. So I'm suggesting it's akin. I couldn't find a mass case that said that it was improper for a prosecutor to state that we could have charged him with an additional crime. But I'm suggesting it's similar to the uncharged conduct cases such as Dwyer, cited in my brief. An example of that, in Dwyer, there were a number of incidents in a rape case that were not charged, and that was reversed by the court. The SJC concluded that the uncharged conduct weighed too heavily on the charged conduct. So it's a suggestion that it is undue emphasis on bad character and a propensity to commit the crime. Another case I'm relying on is Kosick. That was the Jello wrestler prostitution case. She was charged with prostitution. The prosecutor in the closing argument played up the fact that she was a Jello wrestler, implying bad character, suggesting a propensity to commit the crime of prostitution. Here, the prosecutor is pointing out Mr. Scott could have been charged with the crime of resisting arrest.
Why wasn't this a fair response to the defense argument that he didn't resist this field sobriety test, he didn't resist that field sobriety test, and setting up kind of a straw man, and which the prosecutor then knocked down, said, look, he's not being charged with resisting arrest. He's being charged with OUI.
It's certainly true. This is fighting fire with fire, which is permissible under the Mass Guide to Evidence 1113b2, but it is not a license to proceed further to improper arguments. So she can fight back. He did not point out that he was not charged with resisting arrest. He didn't bring up that charge. He used the word resistance kind of generally to suggest that he didn't resist when he was asked for a license or to exit the car.
All of the cases you rely on involve argument that explicitly, I believe, that the defendant could have been charged with some other offense but wasn't.
Yes, Your Honor.
That's not this case, right?
That is not this case. I cite some out-of-state cases where the prosecutor explicitly stated we could have charged him with this additional crime. Even there, I cite several cases that are out of state. One says saying we could have charged him with an additional crime isn't even an error. One says it's improper argument, but the other evidence was overwhelming. One reversed, saying that it was improper, but there were other reasons for reversal. So
What if instead of making this argument, the prosecutor had asked for an instruction and the judge had given it? Ladies and gentlemen of the jury, you've heard evidence about resisting arrest. I instruct you that there is no complaint before you for resisting arrest. You were to only consider the complaint before you. Would that have been improper?
no, that would have resolved the issue, I believe, but he didn't do that. He asked for a mistrial. The judge denied it.
Defense attorney asked for a mistrial.
The defense attorney asked for a mistrial.
So if the judge says, basically, there's another crime out there called resisting arrest, but it's not before you and you're not to consider it, that's not a problem, but if the prosecutor says it in closing, it is?
I think well, I may be misunderstanding what you're saying, but if the curative instruction had been disregard the closing statement as to an additional charge of resisting arrest, I think that would have cured the error.
No, I'm saying if the prosecutor had not said anything about resisting arrest in closing,
Yes.
only the judge says, at the prosecutor's request, the judge in instructing the jury says, the defense attorney made reference to, where somebody at trial
I
made
see.
reference to resisting.
Yes.
That crime is not before you. The only crime before you is what's in the complaint.
I don't think that would have been a proper instruction. I mean, that would have introduced the problem. I think he can use the word resist. He's not prohibited from using the word resist, and the only way you can get back is by saying he's not being charged with resisting arrest. I don't think that's what it would be the correct way of resolving the issue. I'm going to move on to the second remark. The prosecutor said she was talking about the smell of alcohol. She said she correctly quoted Mr. Scott or Trooper Murray's statement as to Mr. Scott's statement. I'm just trying to get my friend home. That's on page 164 of the transcript, and that tracks the statement on page 67 of the transcript. Then she says, in regard to the smell of alcohol, so where is it coming from? Because the defendant said he had nothing to drink. Why would somebody say they had nothing to drink, or why do people lie about having how much they've had to drink? Usually it's because they've had too much to drink. So that is an unfair inference. I mean, that's not really what he said. He dodged the question of have you had anything to drink?
I think we can agree that's not what he said. What if if counsel had instead argued the defendant evaded the trooper's question about how much he'd had to drink? Why would someone evade that question? Usually it's because they've had too much to drink. Would that be permissible?
I think that would be permissible, yes, Your Honor. That would be a correct statement of the record. This is not a correct statement of the record. It's asking to draw an unfair inference.
Well, why is it unfair? I mean, yes, he did not say, I didn't have anything to drink. But he did evade the question.
Well, I think if he evaded the question, that would be accurate. That would be a fair commentary on what the statement was. When you characterize it as a denial, then you are misstating the record in a way that seems to shift the burden of proof onto the defendant to rebut that in some way. So I think that's the distinction there. Also the commentary, the particular commentary, injects personal opinion, which is improper.
If it would be proper to argue, why would someone evade that question unless they'd had too much to drink? Why is
Oh, I'm sorry. I'm going to answer that question as saying that that would be improper too, because that's a personal opinion.
Why is it, I mean, the prosecutor says, I would suggest to you, why would someone say that? Usually it's because they've had too much to drink. Isn't that asking the jury to draw a permissible and arguably reasonable inference?
Well, I don't believe that is a permissible inference to be drawn, Your Honor.
If instead of making this argument in closing, the prosecutor had asked for a consciousness of guilt instruction, that if you may consider if someone lies to the police or evades a question on consciousness of guilt, would that have been proper if it came out of the judge's mouth?
Well, I'm not sure if a particular lie is a consciousness of guilt, is evidence of consciousness of guilt. I didn't really go into that in my brief. I'm going to answer that no. I don't believe that's accurate. If I could move on to prejudice, I'm suggesting that there are two errors here, and that prejudice should be determined by the cumulative effect of the two errors. In regard to prejudice, I think it goes to the heart of the case. I'm suggesting that this is the key question is impairment. The elements of operation in public way were stipulated to. So the jury is determining impairment. Here, I think it's the heart of the case. The other evidence is not overwhelming. I think the case turned on a mixed results on the field sobriety test. Trooper Murray's testimony was that he did not pass the walk and turn test. He didn't expressly say that about the one-legged test. He did say that he stayed on the one leg for 30 seconds and counted up. He did state that that he lifted his arms slightly during doing that. Plus, he counted a little too fast. So he critiqued it a little bit, and then he said he passed the alphabet test. He hesitated at 46 and counting backwards from 56 to 42. I think that's a pass. That's how it was argued by the defense attorney in his closing. So I'm suggesting the field sobriety tests are a mixed result. If you mischaracterize the statement and point out that they could have charged him with resisting arrest, that kind of tips the weighing of those factors in a relatively close case. So I'm suggesting that the errors, the cumulative effect of the errors was prejudicial. I have one other argument, which is a Gallagher dissent argument. I filed a 16L letter. There now is a supplemental instruction in the model jury instructions for the district court as of March. This doesn't really relate to this particular case, except that it demonstrates the Gallagher dissent instruction is now Massachusetts practice.
What do we do with Commonwealth v. Waite?
I'm sorry?
Commonwealth v. Waite, a case that came down a few days ago.
Yes, Your Honor. Well, they rejected the Gallagher dissent argument in that case, certainly. Also, Marino, that came out after my brief was filed. Similarly, they've rejected it. It's not required. I'm suggesting that in this case it applies because there was testimony that Trooper Murray was trained at the academy in administering field sobriety tests. That's on page 68. So
that word portrays that's in the model jury instruction, when the Commonwealth portrays the officer as an expert, what evidence amounts to portrayal?
Well, here, page 68, that he was trained at the academy, that implies that he had specialized knowledge. That's the type of expertise under 702. So it's not like he's, a PhD expert. He has specialized knowledge based on his training at the police academy. That's in the transcript, so I'm suggesting that that is a factual, a record basis for making this claim.
If there was a witness who was a bartender who testified that he drank a lot in college and had been a bartender for years, and then described a defendant's symptoms, would a defendant be entitled to Gallagher dissent instruction?
Well, yeah, that would be a lay opinion. That would be, even though he's more familiar than most people with people drinking, it's a classic lay opinion to determine whether somebody's been drinking or is impaired by alcohol. It's a classic example of a lay opinion.
So the jury should be told that it's a lay opinion?
They should be, if there's a question as to the jury misunderstanding the status of the opinion. If they don't realize that it is a lay opinion, if they think it's based on specialized knowledge, then they might give it undue deference.
But aren't we bound by weight, which says if you don't ask for it, it doesn't create a substantial risk of miscarriage of justice?
Well, I'm suggesting that it depends on the facts of the case. Waite had slightly different facts.
All right.
Thank you, Your Honor.
Yeah.
Attorney Maddox, I circle back. I wanted to make sure you had time for your second argument on the instructions. But as to the alleged errors in the closing argument, our analysis starts really, was there an objection, which inures to your benefit, your client's benefit. There was an objection. There was not a contemporaneous instruction, which again inures to your benefit, correct?
Yes, Your Honor.
As to the heart of the matter which you referenced, perhaps the statements as to the misstatements of evidence went to the heart of the matter. Is that correct?
Yes, Your Honor.
And also to his credibility.
Yes.
Which is central to the case, you'd agree?
Yes, Your Honor. Also, the resisting arrest emphasized a particular factor that weighed in determining impairment. So that kind of put the Commonwealth's thumb on the scales on that particular question as well.
But for our analysis, there's a bit of a heightened scrutiny because there was no contemporaneous instruction.
That's correct, Your Honor.
And the court also looks skew at misstating the evidence, so it essentially boils down to, as you touched, or a focus would be the prejudice. And essentially, did these remarks in isolation and context with the remaining of the closing argument, did they influence the jury?
Yes, Your Honor.
That's your argument?
That is my argument, yes.
Assessing whether they influence the jury, I'd ask you again, the Commonwealth states they have a very strong case. And they say the errors didn't really impact or wouldn't have impacted, I'm summarizing the jury because of their strong case. Can you just again summarize your position of the strength of their case, beginning with the alleged operation as testified to by the witness?
Certainly, Your Honor. I'm suggesting that the key factor was the field sobriety test, and they were close. So it is true there were other factors. There was speeding. He was going 75 in a 55-mile-an-hour zone.
Not uncommon in Boston, but there was swerving as well?
He swerved from one lane to another, yes, Your Honor.
And he slurred speech?
Slurred speech, bloodshot eyes, glassy eyes, uncooperative, stiffened his hands while being handcuffed. So he had uncooperative behavior, but I'm suggesting that the alternative narrative presented by the defense attorney was that he was angry about being unfairly arrested after doing pretty well on the field sobriety tests. So that's the alternative way of looking at his lack of cooperation while being handcuffed. But I'm suggesting it's a close case if you look at the field sobriety test, especially the one-legged test, where he may not have had an A+ on it, but, you know, he passed it.
Okay, my final point is, again, the judge did instruct the jury multiple times that closing arguments aren't evidence. Is that not sufficient to cure the error?
I don't think so, Your Honor. I'm suggesting there should have been at least a contemporaneous curative instruction, although it is true that the final instructions followed shortly thereafter.
Very good. Thank you, Attorney Maddox.
Mr. Januszewski, is that correct?
Almost, Your Honor. Januszewski. Good morning. Andrei Januszewski, Special Assistant District Attorney for the Commonwealth, asking to affirm the defendant's convictions. I don't want to spend too much time on the Gallagher dissent issue simply because Moreno and Waite this court is bound by those two decisions. And the citation for Moreno, which had just come out when I filed my brief, is 102 Mass App Court 321. So looking at the statements, the two statements, so wasn't charged with a resisting arrest. I find it hard that the jury would have thought he was charged with a different crime, even when the prosecutor told him, the prosecutor explicitly said he was not charged with that crime. And I think that was a fair response to the defendant's argument in closing, which really focused on the lack of resistance in certain areas. And throughout her closing, the prosecutor really did summarize. She said the trooper told you the good and the bad. There were things that certainly went in the defendant's favor in this case in terms of the way he handled the field sobriety tests in certain aspects, or maybe the initial sort of encounter. He didn't resist at the beginning. But the defense counsel and continued to bring up resisting. And so I think that was a fair response. The second statement, though, Judge Sachs, I guess maybe I hastily conceded that it was an improper statement. As I read, when I was sort of reading the transcript, it's pretty forceful that the prosecutor says the defendant said he had nothing to drink, and that's not in the record. So for candor to the court, I felt the best was to concede that point. There was an improper misstatement of the evidence, and we can go to the prejudice analysis. Although it is true the defendant didn't directly answer that question from the trooper. So I think there is an argument, but I felt just more comfortable conceding that point and going to prejudice. So the evidence was quite strong in this case. I wouldn't say it was overwhelming, but it was strong.
Can we focus a little bit more on the effect of that misstatement of the record? Counsel has argued that it shifted the burden of proof and injected the ADA's personal opinion. What about those points?
I viewed it more as a misstatement of the evidence. I don't know that it's a shifting the burden of proof. And even if we could view it that way, the jury were instructed that the burden of proof stays with the Commonwealth the entire time. A personal opinion, I don't see that as a personal opinion either. I see it as in the context of a fairly lengthy closing argument in a pretty hard-fought OUI trial. The prosecutor misremembered what was said, and so I see it more as a misstatement of the evidence. It's a very small piece of a 10-page closing argument, just a few lines of argument.
But the problem is, though, it's a misstatement of, it's putting words in the defendant's mouth. So it's not like you're misstating public way or, putting his foot down on the walk and turn or something. You're misstating statements of the defendant.
Right.
So that's the problem.
I agree it was a problematic misstatement. And I think it also, and that's why I'm not even saying it goes to the heart of the case. The first statement I don't think goes to the heart of the case about resisting arrest when it's an intoxication case. But I think the second statement does. But I think when you look at the evidence, the judge instructed the jury.
How is it damaging, and perhaps I should have asked this of Mr. Maddox as well, how is it damaging to the defendant to say he denied that he had anything to drink when he actually didn't explicitly deny it? Yes, it's a misstatement, but how does it hurt the defendant's case? If, of course, the ADA had said the defendant admitted that he'd had a lot to drink, the prejudice would be obvious, but this is the reverse. So
it is the reverse. I think maybe if it was on its own, it really wouldn't hurt the defendant's case as much, but the fact that they go into the second part of that paragraph about sort of lying, why would someone say they had nothing to drink, so it sort of compounded the error, I think is problematic. And so that's why I want to focus on those prejudice pieces. But it is true. I mean, the prosecutor didn't say the defendant admitted to consuming 5 drinks. There's certainly nothing like that. And so I think it's important that obviously a closing argument has to accurately summarize the evidence. And here, it's not accurate. So that's sort of my view on it. But then when you look at the strength of the evidence here, We have the erratic operation, as Judge Smith noted. Glassy eyes, slurred speech, there was unsteadiness, poor performance on at least the walk and turn test. And it's absolutely true that some of the events that transpired at the stop weigh in the defendant's favor, but those are weight of the evidence questions. Those are for the jury to decide whether he was intoxicated or not. The judge 3 times instructed the jury that the closing arguments are not evidence here. Once at the beginning, twice at the end. In the context of a short trial, I think the jury was pretty well aware that these are just arguments. The case law says they're able to, the jury is able to discount improprieties that are mentioned in closing. And again, just a small part of the closing. So it was a relatively lengthy closing, a pretty hard-fought OUI case. I think there are a few good cases on this. I would just point the court to Waite is one of them. There was 3 instructions plus the strength of the case there. In other cases, Deloney, 59 Mass App, 47. There, the prosecutor made some improper comments, and the court said it was a brief error on an 11-page closing argument. So I would sort of note, for those reasons, I think although there was an error, at least one of the statements, there was no prejudice to the defendant. Unless the court has any further questions, I will rest on the brief.
I think that does it. Thank you very much. Thank you both for your arguments.
Thank you.
Our next case is 22P208, Commonwealth versus Joshua Jenkins. And it is a partially impounded case, so I'd remind counsel to keep that in mind. Mr. Gleason.
Thank you. Good morning, Your Honors. Attorney Thomas Gleason for Mr. Jenkins. I'm sorry, Judge, I didn't hear your comment that you made just...
I just said Mr. Gleason. With that comment?
Before that, as we were approaching the bench.
Oh, yes, that this is a partially impounded case. I believe the name of the complaining witness or victim.
Thank you, Judge. Your Honors, as I'm sure you're aware, there are essentially 2 issues that have been raised by the defense, and that is relative to a jurisdictional issue, which we raised initially, and then also there's an issue relative to the denial of a motion to suppress. I was going to start with the suppression issue and discuss that. In terms of the decision that was made relative to this was a issue concerning statements that my client made during custodial interrogation on the date of the offense, which I believe is back in March 6th of 2018. And essentially the issue was for the court is that there had been a prior motion to suppress which had been allowed relative to the stop of a motor vehicle, which eventually led 3 hours afterwards to this interrogation that took place that was being contested. And the issue was for the court is whether or not the attenuation issue, whether or not there had been a sufficient time had passed and certainly other factors to dissipate the taint of the illegal police action that the court had found on a separate motion to suppress relative to the stop of the motor vehicle. As Your Honors are well aware, there are essentially 3 factors that are involved in the attenuation argument, and that is temporal proximity in terms of time, whether or not there exist any intervening independent events that have occurred which would justify the police interrogation, and then the purpose and flagrancy of the police conduct at issue. I would also mention, Judge, that my review of the law is that when you're dealing with when the issue is dealing with admissions or confessions, that there is an additional factor that the court needs to consider, and that is that plays into this, and that is the issue of consent. We say that those factors have been met in this case.
Consent meaning whether the statement was voluntary or?
As I understand it, Judge, in terms of dealing with a further issue that with attenuation is that needs to be addressed. If you're dealing with an admission or you're dealing with a confession, the issue of whether or not the statement is voluntary, whether there's been a valid Miranda waiver can play into that overall.
Is the interview itself in the appellate record before us?
I believe, Your Honors, I'm not sure that the record reflects that. I know that there was a request that was made by the court that it be provided.
I guess my concern or my question is that if your argument is relying on the sufficiency of the evidence of what happened during that interview, like Miranda and voluntariness, it would have been nice if you had put that before us by moving yourself to transmit it with your brief.
I certainly can understand that, Judge, and I can't disagree with you on that. I think it's not, we don't intend on making an argument, I'm not going to make an argument that that it was an invalid waiver or that it was an involuntary statement. I do say, though, that there were things that happened at that interview that are relevant to the issue of attenuation and whether there's been dissipation of the taint, and I can explain that, Your Honor. Going first with the temporal proximity, just going through the factors,
Why isn't 3 hours enough?
Well, it depends on the circumstances, Judge. I mean, it's a totality of the circumstances type argument. I know Your Honor is familiar with the cases, and there are time periods which have been much less than 3 hours. There have been time periods there have been much more than 3 hours, and attenuation is dependent upon not only that factor, but these other factors and the interplay between all of those factors. So, but clearly, when you're talking about this case, at least with respect to that factor, is you're dealing with a situation where this interview is taking place on the date of the offense, the date when the person was arrested, began slightly less than 3 hours after he was taken into custody. I believe he was taken into custody about 1:30 in the afternoon, and this interview started at about a little after 4 o'clock in the afternoon. So I think that you have, at least for that factor, you have that issue, and it works to the favor of the defense. But
there's some facts we don't have, counsel. They may be contained in the interview. For instance, was Mr. Jenkins given the right to make a phone call? Was he advised to have an attorney? What else happened while he was in custody that would affect the attenuation?
Well, I think going to that factor, Judge, I was going to deal with that last, but I'd be happy to deal with it now, and Your Honor would ask the same thing. I apologize. Is during the interview, right at the beginning of the interview, there's a period of time where the officer, the detective, is going through the issue of Miranda. He gives a piece of paper to the defendant, indicates that that's his Miranda waiver, and then he goes through it with him and explains it to him and reads it to him and asks him to sign it, which it appears from the video that the defendant in fact signs. But what's relevant to occur, that occurs there, which the defense thinks is quite important, is that there's a period of time where the officer, the detective, he announces to the defendant, before he signed the Miranda waiver, he announces to the defendant that you're here about words to the effect of incident 2014-04418. And what happens after that is that the defendant pauses. I think it's obvious, my inference is anyways, but I think it's inescapable, is that from his facial expressions and his body language and a pause that in his after he learns this information, that he's trying to figure out, why am I here? Because he does say, the officer does ask him at one point, I believe it's prior to the signing of the waiver, does ask, do you know why you're here? And he says, no, I don't know why I'm here, although he's been arrested.
Why isn't the outstanding warrant an intervening circumstance?
Your Honor, could I just finish that one last point for His Honor, and I'd be happy to answer that, So he says this information about the incident number, and then after this pause of a few seconds, the detective, without a question being asked of him, the detective just says, it's just a number. So I'm certainly aware of the law in Massachusetts that, with respect to interrogations, that an officer does not have to tell a subject why they're there or why they're being asked questions. But it's also that the case law in Massachusetts is, and it goes back decades, is that the court frowns very much on being deceptive. And although can't be used, if it's a sole factor, can't be used to vitiate.
You know, I'm puzzled by this because you said a few minutes ago you agree the statements were voluntary.
Well, Judge, we're not making that argument that they're involuntary. Even with this deception, I understand the case law, and the case law is that just that one factor is not enough.
Maybe you could answer Justice Grant's question then about arrest. I mean, the warrant.
Sure. In terms of the warrant is not dispositive in this case, Judge. And the reason being is that I do understand that in situations where there's a stop of a motor vehicle, there may not be reasonable suspicion, may not even be probable cause, and there's arrest, but the police find out later that there's a warrant, basically no harm, no foul, when they've acquired evidence during that arrest. And that happened in this case in part, but the significant difference is that the evidence that's being contested and the evidence that was acquired was not gathered during the arrest.
What information that Officer Back acquired during the stop did Detective Smyth use during the interview?
Well, I think that based on the interview, at least the interview is redacted, the one that went to the jury. So you don't have the whole interview that was introduced as evidence, at least at trial. But I'm not sure, but I believe the indication is in the beginning of the interview, he asked about this incident that happened earlier in the day. So
The robbery.
Yes, yes. They asked about that. But going back to the warrant, Judge, to answer your question, the problem is, the problem is that, or the issue is that when you have, even if you don't know about a warrant, but you have a warrant, you would have acquired the evidence anyways, because you made the arrest and you made a search incident to arrest, you did an inventory search, plain view, whatever it is that would have happened in the arrest with the warrant, you gathered evidence. And
Well, what was the evidence that Detective Smyth used during the interview that was gathered during the arrest?
Yeah, I'm not sure, but I don't think that's the issue, Judge. The issue is that the evidence that we're contesting here was not gathered during the arrest. It was gathered 3 hours later as a result of an interview about something other than the arrest.
So that would weigh in favor of attenuation.
Right.
Correct?
Correct. Okay. All right. And just getting back to the last point that I was finishing on is we say on the purpose and flagrancy element that you have, or going to intervening events, is that there was no intervening event in this case. This was an ongoing investigation that had been going on for a period of time. It was just a continuation of that. And the purpose and flagrancy is you have, of course, the judge has already decided that there wasn't reasonable suspicion for the stop of the motor vehicle, but in addition you have this statement that we say can be construed as a misrepresentation, that it's just a number when the representation is made about why you're here. There's a number of 2014-04413. It's not in the record if that incident number is related to the ongoing prostitution investigation, or is it related to the arrest that happened earlier in the day?
Or the outstanding warrant.
Or the outstanding warrant. So and then the response is after the pause, where you can see that the defendant's mind is working and he's trying to figure out why he's there, the officer says, well, it's just a number. Well, it's not just a number. It's not just a number.
You said something earlier about the interview being redacted.
Yes.
Was there an unredacted version of the interview before the judge at the motion to suppress?
I don't know the answer to that question, Judge. I would assume so. I would assume so. I mean, I know that it was redacted for trial purposes because of the earlier motion to suppress.
Also, can I direct you back to whether or not there was an intervening event that would support attenuation? The Commonwealth is relying on the warrant. You've addressed that. I'm not sure fully, but you've addressed it. The Commonwealth also relies upon this other investigation, the interview of the named victim. What do you say to that argument? And more specifically, was Mr. Jenkins confronted with this interview during his interrogation?
Well, I think going to your latter point, Judge, that's the point that I'm making about what we perceive as deception, is that he was not told it was about the prostitution matter.
During the entire interview, was he ever confronted with the human trafficking evidence, quote unquote, the evidence from the named victim or the evidence of the text messages? Was he confronted with any of that evidence?
Not in my memory, Judge, in the redacted video, and I've watched it a couple times very recently.
And the reason I'm asking is the case law is pretty clear, and Bradshaw and the Commonwealth, that that can serve as an intervening event, a person who was confronted with new evidence after an illegal arrest. But you're saying that didn't occur here.
I know that it was discussed, Judge. Obviously, the redacted tape speaks for itself, but my memory is that he's asked questions about, have you been to Las Vegas, and do you know this woman? Are you a pimp, or are you involved in prostitution? But I don't believe, my memory doesn't, I don't recall that specific information. And I would just say, Judge, that it's by definition, it's not intervening. I mean, it's not independent, because I think the law is focused on, as I would understand it, is that between the time of an arrest and an interview, say, that there's something new that happens, something unexpected, which would justify why it is that officers are taking the steps that they're taking, which dissipates the taint of what they had done previously.
And the new thing here is that Detective Smyth hears the defendant's name over the radio, goes to the scene, interviews the victim, and then goes to the jail or the holding cell and says, will you talk? And then asks him about this completely unrelated investigation. How would suppressing this information serve the purposes of the exclusionary rule, which is one of the things that we look at in deciding how far to extend the rule and how, and what constitutes attenuation? Isn't this completely unforeseeable from when Officer Back makes the stop that turns out to be not supported by reasonable suspicion?
Well, I think, Judge, that the whole purpose of attenuation and the whole discussion is we're focused not so much on the defendant and his conduct and how it affects him. We're focused on the police and deterring them from the type of behavior that we want to deter them from.
So could the police have known, could Officer Back have known when he pulled over the defendant based on the sweater, that this human trafficking investigation even existed, and that Detective Smyth was going to come question the defendant about it? Is that the kind of thing that Officer Back should have known, I better be sure that I have a basis to pull over this defendant, because I don't want to get any evidence on that human trafficking investigation thrown out?
Judge, I don't know the answer to that question, and I understand your point. I suspect not. I suspect not. But the point of...
Suspect not what?
That he didn't know.
That he did not know.
That he did not know, and it wasn't a plan. But you have his misconduct, which is, pulling over without reasonable suspicion, as the judge has determined. But I'm talking about Detective Smyth. He's the one that does the interview. He's the one that finds out about it, comes there, and we say it's deceptive upon request not to tell this gentleman why he's there and why he's being spoken to.
Okay, so without seeing any further questions, thank you for your argument.
Thank you.
Ms. Campbell.
Thank you. Good morning, and may it please the Court. Kaylin Campbell, on behalf of the Commonwealth, we ask you to affirm the defendant's convictions today. I'll start like my brother did with the second issue, the motion to suppress issue, but I would like to state that almost none of what my brother just argued was actually argued in his brief. He doesn't challenge the voluntariness. He doesn't, I just read through the second issue brief. The word deceptive does not appear anywhere in there. His argument about the incident number or the surprise of the defendant's face is entirely not contained within his brief. I would say because of that, the Commonwealth didn't respond to that issue because it wasn't aware that that's what the defendant was arguing. Because of that, the Commonwealth didn't move to put the interview in the record because it did not appear that that was what the defendant was arguing. So I asked that the court confine itself to the issues that the defendant did raise on his brief, which was not most of what he just argued in this case. That being said, to ask a question, Justice Grant, that you asked, I just checked my notes and it does not appear that the interview was presented to the judge. The focus of the evidentiary hearing was more on the lead up to the interview, what happened before the defendant was interviewed, which makes sense when you look at the attenuation doctrine because they consider the length of time, the temporal proximity.
Just to interrupt you, before they begin the testimony, there's a reference to, Your Honor, have you viewed the video?
Is there?
There is.
Okay, okay.
And I haven't been able to find out, but, so there was a motion to suppress the stop, and then there was a motion to reconsider. And then the judge ordered the defense to respond to the motion to reconsider.
Correct.
We don't have the motion to reconsider.
Okay.
But it may be that the audio or the video
Was attached to it?
Correct, but we don't have any of that.
So to explain sort of the chronology of how this happened, there was a motion to suppress the stop. There was a line which says, and we also moved to suppress the statement, but it was never the focus of the first evidentiary hearing. Once the judge issued his first opinion, the statements weren't addressed at all in any way, so it was unclear to the Commonwealth whether the statements had in fact been suppressed. So they filed a motion to reconsider, and at that motion to reconsider also talked about the statements in the attenuation doctrine, which I can move under Rule 8 to include the motion to reconsider. But I would say that the focus of my brother's brief was not anything having to do with the voluntariness of the statement. It had nothing to do with trickery or deceptiveness. I would say, though, when you're looking at the argument that was raised, which has to do with the attenuation doctrine, the court, and this was the focus of the hearing before the judge, it was all the testimony about the lead up to the interview. There was some slight testimony about the interview itself, but mostly it was that Detective Smyth, who was not involved at all with the stop of the defendant that day. He had started the human trafficking investigation. It was in late February, so before the stop had even happened, which was in March. He's just overhearing on the radio. He hears the defendant's name. He hears the victim's name. He decides to go down there. I would say that separates it from when you're looking at the exclusionary rule, and the purpose of the exclusionary rule is to deter police misconduct. At the time, Detective Smyth had no way of knowing whether this was a bad stop or a good stop. He wasn't trying to take advantage of any sort of flagrant police misconduct, especially if you look at the judge's ruling, which is that this was largely a judgment call. They got a vague description, and there was a question of whether that description was sufficient enough for purposes of reasonable suspicion.
Can I ask how the discovery of the arrest warrant makes any difference? And you rely on Utah versus Strife, but there, before, the issue was whether the fruits of a search incident to arrest should be suppressed. And there, before the arrest, the police discovered there was an outstanding warrant. Here, as I understand it, that wasn't discovered until after the arrest. So how does that intervene?
So I think it is intervene. If you look, my brother makes the argument that this arrest was the but-for cause of the defendant being taken into custody, that there was an open arrest warrant.
We know that but-for isn't enough, right, under Long?
Correct, correct. I know that but-for isn't enough, but if you think of it, even the defendant's custodial status, there was a valid basis by which the police could have taken him into custody because...
When they did. It doesn't interrupt the but-for, does it? If they hadn't stopped him, validly or not, they never would have discovered he had an arrest warrant.
Correct, but let's say they had just run his plates and found out that he was driving the car, they did have a permissible basis by which they could have taken him into custody.
Right, but this is not an inevitable discovery case or an independent source.
It's not, but I think it's related because it shows that there was a legal basis by which the police could have taken him into custody. The open warrant is not negated by the stop. they still have a basis to place them into custody. I'd say even without that, the number of hours that go by and the fact that they've already, they go and speak to the victim, they get more information about the human trafficking investigation, that the detective who speaks to him is not involved in the original stop, is just involved in the human trafficking investigation.
We distinguish the different parts or types of information that were gained during the interview. For example, if the defendant was seeking to suppress parts of the interview that related to the reason for the stop, in other words, the alleged assault and battery and the theft of the phone, would that be attenuated? Could we rule that there was insufficient attenuation for that information because it was perfectly foreseeable to Officer Back that when he made this stop and the defendant was arrested, he would be questioned about the incident for which he was arrested?
So it's almost as if, like a search warrant, whether that information can be severed out.
Well, whether the information gained in the interview could be divided up into things that were the foreseeable result of the
Consequence.
stop, which turned out to be bad, and the things that were totally random and unforeseeable.
So aside from, I don't know of any cases under the attenuation doctrine dealing with an interview that would hold that. I think in search and seizure law generally there is that doctrine, and like I said, you can sever out the parts of a search warrant that you don't have, that you seize, that you don't have probable cause for. I think here, though, when you really look at what the attenuation doctrine is looking at, it's meant to, I think a situation like this where there are other things that come to play between something that is an illegal stop and something that happens later, and really is looking at the connection between those things. And I think where Detective Smith was not involved in the original stop, where his investigation had started before that, where he speaks to the victim who gives more information about the human trafficking information, I'd say all those things collectively are enough to hold that the attenuation doctrine.
But under attenuation, under intervening event, you rely on, which is a little bit different from the Superior Court judge, you rely on the warrant, which we've discussed, and you cite Utah. There's not a single case in the Commonwealth that relies on the warrant for attenuation, is there, that you're aware of?
There's not.
In fact, in Souter, Justice Agnes distinguishes, he essentially explicitly says we're not relying on that opinion.
Correct, correct.
So you're relying on Utah, which, as my colleague, Justice Sachs, has said, is a little bit different circumstances here. And you're also relying on this investigation, the interview of the named victim.
Correct.
But my review of the law is really the impact of any intervening event must be on the defendant, not on law enforcement.
I don't believe that's true. I think if law enforcement gains more information, let's say, for instance, there's something that happens at the scene and then the defendant, you gain more information, so you now have probable cause to speak to the defendant. I think that would be sufficient under the attenuation doctrine to then go try to speak to the defendant.
Well, the attempt to speak with the defendant, I spoke to broadly, but my interpretation is whether or not the defendant's making a willful decision to make a voluntary statement depends on whether or not he's aware of these intervening events, whether or not he's aware they have evidence of human trafficking that he wasn't aware of when he was stopped. Again, Bradshaw stands for the proposition that in this case, if he had been confronted with a human trafficking investigation during the interview, that could serve as attenuation. That could serve as an intervening event.
And I don't read it to, I don't read the cases to require such confrontation. And I think if you look at the proximity, they spoke with the victim, they got this text messages that's just before they speak with the defendant. So it's not as if they have this information for a while and look at it and then confront him with it. I don't read the cases to require that, to be that narrow, to require that specific type of action. It seems to me more, and the cases, and maybe this is just by merit of the cases that seem to exist on the attenuation doctrine in Massachusetts, seem to focus primarily on this temporal proximity, that a few hours is enough, that, there aren't really that many cases that deal with the attenuation doctrine generally, and the ones that do seem to turn on whether sufficient time has passed. But I would say that I don't read it that narrowly. I'd also say that the Commonwealth isn't relying solely just on the fact that this warrant exists. I think it's looking at it in the totality of the factors, and that it's one of the factors that supports that there is attenuation in this
You're saying
instance.
totality, though. What factors are you referring to?
Oh, sure. So I think if you look at it as the length of time that's gone by, which is a few hours, there's that they've spoken to the victim who's given additional information. It's that the unlawful search was not integral to, I think, either the decision to speak to the defendant, because Detective Smith had already started this ongoing investigation, and it wasn't integral to the type of information that they were trying to get. So I would say all of those factors support that there is sufficient attenuation here in this case.
Did Detective Smith use any information or evidence that Officer Back had gleaned during the stop? Did Detective Smith use any such information during the interview?
I mean, they asked him a few questions about what had happened earlier, but no, on total, the interview is not about the stop.
As to the third long factor, the purpose and flagrancy of the misconduct, whose misconduct is that? Is that Officer Back's misconduct or Detective Smith's misconduct? Because it sounds as though defense counsel is saying, by referring to an incident number, Detective Smith was committing misconduct.
Correct, and so I think it would have to be the officer. It's hard to say because sometimes they look at it as a consolation, because a lot of times it's the same officers who are investigating the same thing, right? So they stop someone and then they decide to speak with them, or then they somehow find information. Here, I think it's important that, I don't think that Detective Smith engaged in any misconduct. He was not involved in the original search. I don't even think there was a challenge, aside from hearing what my brother stated here today, that he engaged in any misconduct during the interview. If that's certainly what he's arguing now, or if that's integral to the panel's decision, I would like a chance to brief it, because that's not what I understood the argument to ever be. But no, and it was before the motion judge, and the motion judge did not find that there was anything that Detective Smith engaged in any misconduct related to this interview. But even if you're looking at it as the investigating team or all of the officers that are involved in it, even the judge found this. He didn't find that the police misconduct as it related to the original stop was flagrant in any way. As the judge said, it was largely a judgment call as to whether the decision, and it was largely a legal judgment call on the judge's
Based
part.
on the vague description of the
Based
sweater.
on the vague description. So it wasn't something that was blatantly there was no reasonable suspicion, and they decided to stop the defendant. I'd also say that between the stop of the defendant, they then speak to the victim again, who gives more details, at least about the A and B and the theft. So it's not as if by the time that they speak to the defendant that they don't have probable cause to arrest that defendant on that charge, irrespective of the stop.
Do we know specifically whether information gleaned from the victim at that time was used in the human trafficking portion of the interview with the defendant?
That, if I could write a 16-letter L letter about that, I just off the top, I haven't looked closely enough at the victim, the statements that the victim gave during her interview compared to the questions that he was asked. They necessarily are about the same things, and I do remember the victim speaking to the police specifically about how she had gone to Texas. There had been an investigation. Her family had gone to the police department previously.
But the police knew that she had gone to Texas, and they were working with the
Correct.
Texas authorities, and
Correct.
they found the victim.
Correct. And I believe it was during this interview that she gives the text messages, which were introduced at the trial, in which the whole plan is laid out. And I believe he was asked questions about Vegas and going to Vegas, so necessarily they had gotten more details from the victim before they had interviewed the defendant.
Do we know if the text messages came off her phone that was in the defendant's possession at the time of the stop? Or was it from a Rule 17 summons?
No, if you look, the text messages, and if you look at them in the record appendix, it's a photograph of text messages. And so there are she called the defendant Loafy, and the top says Loafy, so inferably, they're the text messages that are taken off her phone. And it was not, based on the way that they look, it was not a Rule 17.
Did the defendant ever move to suppress the phone?
I believe he moved to, I believe that the stop was an attempt to suppress all evidence related at the stop. The problem was when they stopped the defendant, the victim said, "That's my phone," and he gave her back her phone.
The defendant gave her back her phone.
Correct, at the time of the stop. She comes over to the car, she says, "Yes, that's the person that I'm talking about, and look, he has my phone." I see I have 9 seconds left, but if the court has no further questions, I'll rest on my brief. Thank you.
All right. Thank you very much. Thank you both for your arguments. Our third case will be number 22P1049, Heidi Connelly versus Alfred, FISICHELLI, and others. And before we get started, Mr. Doyle, I just want to make sure I understand correctly. Mr. Pinto will be arguing for 9 minutes, and Mr. Caffrey for 6, is that correct?
Correct, Your Honor.
All right, thank you. All right, Mr. Doyle.
Thank you. Good morning, and may it please the court. My name's Jerry Doyle. I am the attorney for the appellant Jody Doyle. This case involves the appellee's attempt to claim an implied easement over Doyle's property, which is registered land, governed by the registered land statute. The land was originally registered Salisbury Beach in 1913 in the name of the Salisbury Beach Associates. All of the deeds, the registered land from Salisbury Beach is conveyed out of a master certificate of title 1247. All of the lots that are involved in this case are shown on subdivision plan 3200 XV or 3215. This case involves two parties. One party is Mr. Caffrey's clients own the oceanfront property. They're tandem lots. Lot 1 is facing the ocean. Lot 2, which is in back of it, bounds on the State Highway, North End Boulevard. And Mr. Pinto's clients are across the street on the State Highway. There is also a Lot 1 and a Lot 2, so don't confuse the two Lot 1s. And there's a Lot 8 that's across the street in the highway.
So if I may ask a question, what was the grantor's intent in creating these streets, such as 8th Street East, if not to provide access for at least some of the owners in the area to the beach?
I think it's necessary to understand the history of Salisbury Beach. Prior to 1933, Salisbury Beach Associates owned the sandy portion of the beach. And they also owned all the registered lots on the beach, which they deeded out one by one. So those particular streets would give Salisbury Beach Associates access to their own property. In 1933, the Commonwealth of Massachusetts purchased all the sandy beach on Salisbury Beach. So prior to that time, and the plan is a 1920 plan. So prior to 1933, Salisbury Beach Associates would have access over their own streets to access the beach. After that, having those streets, retaining the fee in the street would enable the Salisbury Beach Associates to grant easements to whatever lots they wanted to do, as they did in some cases in 1965.
Like with the Willows Realty Trust.
Excuse me?
Willows Realty Trust.
They did Willow Realty Trust. They also did easements. Well, Willows Realty Trust was to 7th Street West, 8th Street West, 9th Street West, 10th Street West.
And others
also did
in
the
the
locust.
ways in the vicinity.
They granted well, the ways to the vicinity, the question they have is where's the easement? It's pretty ambiguous, so there's not really a valid easement ways to the beach. It doesn't define that.
The Willows deed said, and also the right to use in common with others, any ways to the beach which are in the vicinity of or adjacent to various streets, including 8th Street West. I think we'd agree 8th Street East is in the vicinity of 8th Street West.
Well, it wasn't 8th Street. They specifically mentioned the streets on the west as having an easement. You would think they would do the exact same thing if they wanted an easement over 8th Street East.
They said any other ways to the beach. Any ways to the beach which are in the vicinity of or adjacent to 7th Street West, 8th Street West, 9th Street West, 10th Street West.
And again,
why wouldn't that include 8th Street East?
No, I don't think so, because that easement is ambiguous, and I don't think it rises to the level that you have to have for a easement. You've got to be able to know where the location is, where the easement is actually located, and the depth of the easement, and you don't have that. They
This was an
specifically,
express grant from the SBA to Willows in 1965 that granted the right to use for ingress and egress the registered portions of 7th, 8th, 9th, and 10th West, and also the right to use in common with others any ways to the beach, which are in the vicinity.
and that easement is,
It's not enough for SBA to give Willows the right to use 8th Street East to get to the beach?
I don't believe it is. I think the easement's too ambiguous. I don't think it sets.
What's ambiguous about it?
Well, it says any ways to the beach. What is any ways to the beach?
It doesn't say any ways to the beach. It says any ways to the beach that are in the vicinity of or adjacent to 7th Street, 8th Street, 9th Street, 10th Street. Now, we can argue about whether a street a mile away is in the vicinity of 8th Street West, but isn't 8th Street East the way to the beach that is most in the vicinity of and indeed adjacent to, separated only by the state highway from 8th
Even
Street
if
West?
it was, the easement is specific to Willows Realty Trust.
Okay,
not
but
to
it
the
was,
appellees.
but it was of record and in the registered land system at the time that Ms. Doyle purchased this lot. So she was on notice of it. Not only that Willows had the easement, but this was that the ways to the beach could be used not only by Willows, but others.
I agree. I agree. And so on the Jackson case, Doyle would have an obligation to review all the certificates and plans in that registration. And that's what they did. You've got 250 pages in volume 2 and 3 of the appendix that shows all the deeds that came out, the original deeds from the master certificate of title to the various lot owners. None of those show any easements over the street.
Why doesn't the 1920 plan itself, the 3200 XV, whatever it is, itself put Doyle on notice of easements? It's got no east and west boundaries for the locus, and it's got no lot number on the locus.
There's no doubt that you're on notice that you have to look at other certificates and plans in the registration system. You did that. We did that. You've got all of those deeds in the record. None of them show any rights over the locus. In fact, the only rights that are over the locus were granted subsequently in 1972. If the Salisbury Beach Associates intended for others to have easements over the locus, why in 1972 did they specifically grant an easement to the people on the other side of 8th Street East? You've got...
But isn't their intent, the relevant intent, what they intended in 1920, and not what they intended in 1972?
Yes, what they intended in 1920 when the original deeds, when the root deeds came out from that master certificate of title, 1247, that's when you determine what the Salisbury Beach Associates' intent was.
So why is Grace Leach's 1919 deed relevant if it predates the 1920 plan?
Well, if you look at it, it refers to the 1920 plan, and if you look at it, it was actually registered in 1920, but the deed is dated 1919. So that 1919 deed refers to the 1920 plan. And when they did that original deed out to Mrs. Leach, you'll notice that there's an express easement over the beach to the ocean. That lot was landlocked. Lot 10 was landlocked in 1919 when they originally deeded it out. They didn't grant any express easement over the locus, but you fast forward 53 years later, and they granted an express easement to that Lot 10. So that would...
Septic tank.
Excuse me?
To get the septic tank in and out.
Yeah. So that would indicate that the SBA's intent was only to grant express easements and not implied easements.
Well, but that was an easement to get back and forth between the lot and the state highway, correct? As well as for the septic tank. Whereas the implied easement that the judge found was to get to the beach. So the existence of an easement to get to the beach would not have authorized the owners of Lot 10 to get to their lot, would it? That would have to be...
That's correct.
That would have to be expressed.
They would have been landlocked in 1919.
So the grant of that express easement to get to the lot doesn't indicate any view that there was no easement to get to the beach. They're two separate things.
That's correct.
Okay. So you've said in your brief, and the judge rejected this, but you've pressed it on appeal, that there needs to be at least one express easement in the record under Hickey for anything else to be implied from that.
Well, I don't think it has to be like at least one. You've got to have express easements in the record under the Jackson case and under the Hickey case. I'm not indicating that you need one easement someplace. You need easements. That's the point. If you don't have easements in the record, then under the registered land statute, you can't have
But
it.
you agree that under Hickey, you don't need an easement on, recorded with respect to every single lot that's claiming an easement. Okay, so that's a long wind-up to my question. Why isn't the Willows deed, which was on record and presumably known to Ms. Doyle when she purchased this, the single express easement that you need, or you say you need under Hickey, particularly where that certificate referred to not only the easement to the Willows, but also the way to the beach to be enjoyed in common with others?
Yep.
Why isn't that enough?
That easement to Willows Realty Trust was in the record, but it was done 25 years after the original deed's out for the appellees and most of the other.
I'm not suggesting that it creates rights that didn't exist, but it certainly put Ms. Doyle on notice that there were rights and that they weren't only enjoyed by the Willows Realty Trust, but the others. So couldn't that deed be viewed as confirming that at least as of 1965, the SBA thought that there were rights that others had to access the beach over 8th Street East and similar
If the
places?
SBA thought that, they would have known that because they would have granted the easements. And I grant you that that Doyle was on notice, that there were others, but you've got to find those easements. And in the record, there are no other easements.
I thought you just said that you don't need an easement for, an express easement for every single lot. I thought your point was that if you've got an express easement of which the purchaser is on notice, and this is really about protecting the purchaser, then the purchaser has to make inquiry. Now, she would not have found express easements to others, but she would have seen this language in the Willows deed that says ways to the beach to be enjoyed in common with others. And then she would look at the 3200 XV and say, hey, look, there are all these streets.
And that's exactly what you did. We looked at all of those deeds. None of those deeds showed any other rights over the locust. So,
Doesn't the word street,
excuse me?
doesn't the word street imply rights over the locust?
Well, in Massachusetts, simply showing a street on a plan does not grant access over the street. You've got to have something specific.
Is there a case that says that?
Jackson versus Knott says that. You've got the Patel case. I think it was Patel versus the Planning Board of North Andover. There's a slew of cases, they're all cited in my brief, that state that just simply showing a street on a plan does not give you rights. And I think in Jackson, it's to page 711.
I have a question for you about your argument about the 1917 advertisement that was admitted in evidence. Why is it you're saying that's not admissible? And how do you distinguish the advertisement in Reagan v. Brissy in the Martha's Vineyard Gazette quoting Lord Byron?
Okay, Reagan versus Brissy deals with recorded land versus registered land. There's a difference. Registered land has strict compliance. And registered land, you have to look for, what Section 46 says in the statute is that all the encumbrances have to be shown in the certificate of title. There are 7 exceptions to that. Jackson has made an exception to that. So in order to have any encumbrance, it's got to be shown on the certificate of title. In
But
any
is the
encumbrance-
admissibility of an advertisement,
Excuse me?
is the admissibility in evidence of an advertisement different in this? Why are you saying the 1917 advertisement or pamphlet, handbook, should not have been admitted?
Because of the fact that the statute says, I think it's section 54 of chapter 185, says that whatever's on the certificate is conclusive and nothing to the contrary is admissible. What you've got to find, if you have encumbrances on registered land, it has to be found within the registration system. The advertisements were in a book in the Salisbury Public Library, which is not within the registration system.
So your point is not that it's inadmissible as an evidentiary matter, but really that it's not relevant to registered land.
It's not relevant to the encumbrance. You can't take the advertisements into consideration.
Because they're not a part of the
whether there's
registered land.
encumbrance, because it's outside the registration system.
Yeah. Can we go back to your point that the reason for the streets like 8th Street East was to give SBA access to its beach property before that was deeded to the Commonwealth. Was that, I didn't see the judge addressing that, and I don't remember seeing it in your brief. So my question is, was it raised below, and is it in your brief?
What is it, what?
The argument that the reason these streets were created was to give SBA access to itself, access to the beach.
Gives it access to their own property, but it also allows them to grant access, retain the fee in the street. If they wanted to in the future, they could grant easements over those streets to other lots that they deeded out.
And my question is, was that argument made to the judge below, and where is it in your brief on appeal?
I'm sorry, would you repeat that?
Was the argument that the reason these streets were created was to give the SBA access to the beach itself?
I think that's one of the reasons.
I'm asking, was it raised below, and where? And is it in your appellate brief, and where? That argument.
I believe it is in, I believe it's in the principal brief.
Where?
Off the top of my head, I don't know.
Can you find it for us?
I don't have my brief
Let us
with
know.
me.
Let us know after argument.
Excuse me?
And let us know through a 16L letter.
Yep, I can do that.
And where it was raised to the judge.
Yep,
In the record below.
yep.
Further questions? No. All
Thank
right.
you.
Very interesting case. Thank you, Mr. Doyle. Mr. Pinto.
Morning, Your Honor. May it please the Court, Donald Pinto for Ms. LaRoque and Mr. and Mrs. Farrow, who own lots on 8th Street West, directly across the State Highway from 8th Street East, and have used 8th Street East as their access to the beach for decades. The appellants attempt to parse Hickey so that it means what it doesn't plainly say, I think falls apart as soon as you read the case. The proposition that Hickey stands for, and I think one of your honors made a comment along these lines, is that it's the existence of plans in the record that put someone in the appellant's position on notice that there may be others with rights in the streets. The court focused not only when it was talking about the derelict fee statute and ownership of the ways, but in the separate section when it was talking about easement rights in the ways, focused on the progression of development and the series of subdivision plans.
What is the progression of development? We keep seeing that phrase in the briefs, but really that's like a gestalt approach. What progression specifically indicates this intent?
It's a series of subdivision plans. Somebody initially, like in this case, registers a very large parcel. No individual lots have yet been created, and then over a period of decades files individual subdivision plans dividing up sections of that overall large parcel into individual lots, and then creates progressively a network of streets so that all the lots have access to public ways.
I mean, does two... So you're talking about the difference between the 1903 or 1913 recorded or registered plan and 1920 3200 XV? I mean, is that the progression you're talking about? Because has anything really changed since
That's part of the
3200 XV?
progression. I mean, the 3200 XV is the relevant plan on which the parties' lots were created, and 8th Street East and 7th Street East and the western analogs of those streets were created. But it was a much larger parcel than that, and there were dozens of plans recorded over a period of decades.
Whatever progression we're talking about kind of stops with 3200 XV in 1920. That doesn't mean that you lose the case, but
right.
I'm just trying to understand what progression you're talking about.
Right. It's that those, I think it's well over a dozen, might be 20 subdivision plans, and the message from Jackson versus Knott and from Hickey and from the Duddy versus Mankiewicz decision of this course is that somebody buying a lot, someone in the appellant's position, is obligated and charged with knowledge of everything that's in the registration system, all the subdivision plans.
So what do you say to Mr. Doyle's argument that the reason for these streets, like 8th Street East on the plan, was to preserve access for SBA to its own property, which included the beach at that time, and so that SBA could grant easements to others expressly, and not implicitly to other property owners?
I'd say first that that's speculation, and secondly, I think it's entirely implausible when the name of the organization was Salisbury Beach Associates. It was creating a very large beach community of hundreds of lots, trying to market and sell those lots, and of course, they intended for those lot owners, those lot purchasers, to have access to the beach. It was the central amenity that gave value to all the lots they were creating. It was the reason for their existence. And again, they are the Salisbury Beach Associates. So it stands to reason that anybody buying a lot from the Salisbury Beach Associates in the vicinity of Salisbury Beach would have a way to get to Salisbury Beach. And
What's the argument that SBA wanted to retain access for itself made to the judge?
I don't recall that, Your Honor.
Does it strike you as a new argument when you hear it today?
I don't recall it being in the appellant's brief, so it did strike me as a new argument today.
Is there anything in the record before us as to whether or not the Willows Realty Trust is your client's predecessor in title?
I don't believe so, Your Honor.
They aren't, are they? Because that's unregistered land.
Correct.
Okay.
The land that they own.
Okay.
Correct.
They're given easements over registered land, if I'm...
Turning back to Hickey and Jackson, although registered land, the general rule is that when you buy registered land, you're only subject to encumbrances shown on your certificate of title. Jackson created an exception to that, and Hickey applied that exception in circumstances very similar to our current case. And as Hickey emphasizes, when you see a plan, when someone creates a plan and creates lots bounding on a way, that itself, the existence of that plan, puts someone on notice that those other lot owners may have rights in the way. And that was sufficient in Hickey. It was sufficient in this court's decision in Duddy versus Mankiewicz. This court in Duddy didn't get bound up in whether which of the certificates of title had express easements and which didn't, because it was a mixed bag. Some of them did have express easements. Some of them didn't have express easements. None of those certificates of title said your property is subject to the rights of others in this subdivision road. And the court said that doesn't matter. It's the intent of the grantor that can be discerned from the progression of development, the creation of a subdivision with a subdivision road and lots lined up along the road. And it's obvious that it was the creator, the developer's intent that all the lots would have access along that same road.
You spoke about plans showing ways adjacent to properties, and that reminds me of the estoppel point, easement by estoppel that's argued in your brief. I don't understand how that would benefit your clients, since none of them own properties that are adjacent to the locus.
Well, they own properties that are bounded on 8th Street West, which is just a continuation of 8th Street East, just takes you across the state highway. So it's effectively the same way, providing the same access to the beach, just with an intervening street that's parallel to the beach. One other point, Your Honor, and I don't want this to get lost. When the appellant bought their property in 1992, there was an express easement not only in the registration system, but referenced in their deed and their certificate of title for the abutting lot to use 8th Street East. So this isn't a situation.
That's the Fisichellis or the Drevises?
Pardon?
That's the Drevises you're talking about?
Drivus or Drevis. So you don't have to go back in time to 1920 to see what this appellant knew when this appellant bought their lot. They knew that at least one adjoining lot had an express easement over 8th Street East. And I would also suggest that the consideration in 1992 when the appellant bought their lot of $25,000 suggests that they didn't think they were getting a buildable lot with 50 feet of direct ocean frontage. I think it was in the nature of a flyer, hoping to convince a court someday that they had exclusive rights and exclusive use of that lot, and that it would be a buildable lot, hoping for a windfall. And the land court refused to be that court, and I would ask this court to affirm the land court's decision.
How do we decide if, for purposes of your easement by estoppel theory, 8th Street East is the same way as 8th Street West? I mean, they have different dimensions. They've got different names.
Well, they do have different names in that one is east and one is west, and that reflects which side of the state highway they're on, but they are in alignment
right. But
in a straight line.
8th Street West is narrower, I believe.
I don't recall that detail from the plans. If one is narrower than the other, it's by a very small amount. They certainly appear comparable on the subdivision plans.
So is there law on deciding when, in an easement by estoppel context, how far the way goes? I understand that you have, if easement by estoppel applies, then the owner has right to use the whole way. I think that's Murphy, but how do we decide how far the way goes?
Yeah, I'm not aware of a case that deals with the precise issue of when there's an intervening parallel street, as there is here. But the cases seem to distinguish easement by estoppel from an implied easement. The SJC in the footnote in Hickey said, well, there's nothing necessarily wrong with easements by estoppel, but that wasn't the basis for Hickey or for this court's decision in Duddy. It was simply an implied easement based on the intent of the grantor, which can be discerned from what's in the registration system. I say I'm over time, so if there are any, I'll yield to my colleague.
Thank you.
Thank you.
Good morning. May it please the court. My name is Andrew Caffrey Jr., and I'm here today representing Heidi Connelly and Natalie Lucas, who as trustees each own one of the lots on 8th Street East, Lot 1 being the beachfront and Lot 23 being the one on the State Highway. As the discussion has been going on, we're here trying to determine what the intent of the Salisbury Beach Associates was and the understanding of the buyers when they bought these lots many years ago. I think it's very valuable to understand that the initial A plan, just showed rectangular lots that to the east abutted on the beach, and to the west there was no roadway. There was a railway there. Some distance further to the west, you'll see on the A plan that there is a road. And then Salisbury Beach Associates on its own decided, and I believe it's with the advent of the automobile, to lay out these streets and show the new subdivision on the XV plan.
What do you, and those lots that were shown on the initial plan were then divided into two parts on the XV plan?
Correct.
What do you say to Ms. Doyle's argument that those are tandem lots? They were all sold in conjunction with each other, the sort of beachside and roadside parts of the...
That may have been the situation. It's hard to understand how you would buy a beachfront lot and not own the street side lot. Whether it was to give these parties the right to build two houses, one on each lot, I'm not sure. But I think clearly...
So why wouldn't the ownership so you've got, I guess, in your case, we're talking about... which is the beach side?
Lot 1.
Lot 1. So why wouldn't the owners of Lot 23 have access over Lot 1 to the beach? Why would they need to use 8th Street East? And similarly, why would the owners of Lot 22 who own Lot 2 need access over 8th Street East?
Well, because I think, again, back to the intention of the parties, Mr. Alexander, who I think was the first one to buy both Lot 1 and Lot 23, bought on a street. He could have bought one of the other tandem lots and been landlocked that way, but this was a different piece of property that he was buying, and I think there were reasons for that.
Is there do you agree that for owners who don't abut on one of these east streets, like 8th Street East, that, say, the purchaser of lots 22 and 2, G22 and 2, could later on sell one of those and just make sure that lot 22 retains or is granted an easement over lot 2 to the beach?
Certainly, if they were divided out to different owners, I think the buyer of the landlocked one would only do it if he had some access easement over the street side. But in our case...
and can't the same occur with lots G1 and G23?
They could, but why should they? I mean, it was Salisbury
We're talking about whether there's something implicit in the existence of 8th Street East
Well, I think there is. You know, you asked the question earlier. Mr. Doyle said, well, they put in the streets so they would maintain access to their beach property. Well, that argument, I do believe, came up down below, and I remember thinking how ridiculous it is because all Salisbury Beach Associates had to do was to not sell one of the lots, and they would maintain access to the beach. But here they put in streets, which I think purchasers look at streets and they see streets. And these aren't, in many of the other beach cases, they're 20 feet wide or 10 feet wide. This is a 50-foot wide street. And I think if a review of the plan will show that although the streets, the width is not designated, except now we have the width of 8th Street East designated when the plan was prepared for it, but all of those streets on both sides of the highway are 50 feet wide. And clearly Salisbury Beach Associates held out to the public, I believe, that these are streets. And we get to the other ridiculous situation where lots are landlocked. If you look at the XV plan on the west side of the state highway on 9th, 10th, 11th Street, you'll see any number of lots over there that are landlocked. I mean, did they really think they weren't going to have access to the state highway because they didn't get an express grant? I think the lack of an express grant actually supports our case.
Which, I'm puzzled, why are those lots landlocked?
Because if they don't have rights in the 9th, 10th, 11th West, they can't get to the highway. Just as Drevis in Lot 10 couldn't get to the highway if there wasn't either an implied easement or an express easement. And as I said in my brief, I suspect that by 1972, when Drevis was purchasing the lot and his attorney was negotiating a septic easement, he said we should get one for the street too.
Don't the lots on the west front on the state highway?
No, no, no. There are a number of them that do not. They only front on the new laid out street. So if there is no implied easement, they have no access to the state highway. They're landlocked.
Can you identify a specific lot that has that issue?
Yes, on Plan X. Oh, I'm sorry. I'm looking at Plan X14. I apologize, but the west side of the highway, you have the frontage lots that are on the highway, but behind them, there are any number of lots that only have frontage on 9th Street, 10th Street, 11th Street West. So otherwise, they would be landlocked, just as Lot 1 and Lot 10 would be landlocked on 8th Street East. And again, I think a conveyancer said, while we're at it, we should get an express easement, just to be careful. But I think it, again, supports our case that there were no express easements until 1965, when a property owner adjacent to the subdivision, who had no rights to an implied easement, said, I need an implied easement, and they gave it freely. And as the Honorable pointed out, to not only the streets to access the state highway, but to also go across and access the beach. So it's clear that Salisbury Beach Associates held this out as a development where people could get to their houses and get to the beach. And, you know, it is, and Doyle was certainly on notice and should have known better. Thank you.
Thank you. Thank you all. Is that to go number 4? Is that fourth case?
Yeah.
Okay. Are you good for that? All right, our fourth case will be number 22P 1138, Department of Children and Families versus Mother. I'm sure the parties are aware that this is an impounded case and that references to any names should be avoided. And just so I'm clear before we get started, Mr. Cuddle for DCF, you'll be taking 8 minutes, is that correct? All right, and Ms. Gallup for the child, 7? Thank you. Mr. Dennis, whenever you're ready.
Thank you, Your Honor. I just need a little water.
Did you get some?
I did, thanks.
Okay.
Good morning, Your Honors. May it please the Court, my name is John Dennis, and I'm here on behalf of the appellant mother. Mother asks this court to reverse the trial court's termination of her parental rights and for the case to be remanded for retrial with appointed counsel and an appointed guardian ad litem. I'll jump to the two main issues I've raised. One was the validity of her waiver of her right to counsel at trial. There's really two parts to that. One is her ability to waive
Before you
counsel.
get into the substance, counsel, would a better appeal or a more appropriate be a motion for new trial?
There's no reason for that in this case, Your Honor. There was a competency hearing. The judge issued an opinion. The grounds for his decision to grant the motion to withdraw are all in the record.
You mean the hearings on June 7th, 8th, 9th, you consider that a competency hearing?
Yes. Okay. That was the issue. Dr. Flood was there.
We understand the issues, but who testified at that hearing?
He took Dr. Flood's report into account in that hearing, and I believe Mother was on the call.
Well, I think the issue I raised is, was that a competency hearing, or was that, as he referred to, a screening?
The screening, I believe, was with the court clinician. The hearing was with the judge as to whether or not he would accept her waiver. So I don't think there would make what the point would be in redoing the June 6th, 7th, and 8th hearing with the findings that the judge had from the court clinician. Actually, there were two court clinicians who had examined Mother. One with respect to her waiver of the 72-hour hearing with a different clinician than the clinician who evaluated Mother with respect to her waiver of her right to counsel, which that report was June 7.
And then there's the more extensive report from Ms. Flood, I think.
Dr. Flood's
Flood, yeah.
report is the June 7 evaluation.
May I ask, do you contend that the judge applied the proper standard for competency to waive counsel, but just made a mistake on applying that standard to these facts, or are you challenging the standard that he applied?
It's interesting to me, Judge, that in his memorandum, his June 10 memorandum, he never mentions whether Mother's waiver was equivocal or not. He tries to, which in fact it was, because she repeatedly said she preferred counsel, and then the next minute she would say, I'm going to lose anyway. I might as well pilot my own ship. But what I think is, and I go back to I don't think he applied the proper standard. I think as to the ability to waive counsel, he found that the mother didn't suffer from a major mental illness that would prevent her from representing herself. I don't think that's the standard. With respect to the ability to waive counsel, this was recognized by the U.S. Supreme Court in Godinez, which is mentioned in the cases we have, where that court said the focus of a competency inquiry is the defendant's mental capacity. The question is whether she has the ability to understand the proceedings. The purpose of the knowing and voluntary inquiry, by contrast, is to determine whether the defendant actually does understand the significance and consequences of a particular decision and whether that decision is uncoerced. So those are the court's saying there are two different aspects of competency to waive counsel.
Where do we find in our state cases the best statement or a good statement of the standard for competency to waive counsel?
Well, in the care and protection cases, there was William, and as of yesterday, there's a rule adoption of Brianna was just issued, and I submitted that as soon as I found out about it. And it lays out the knowing, voluntary, intelligent, and unequivocal standard. It doesn't really speak to ability to waive that right. And I don't know that there is. I couldn't find one, even in the criminal context, that addressed that specifically.
I'm confused. Are you saying that the mother was not competent to stand trial, or that
I'm not
that her
arguing
waiver
that.
of counsel was not voluntary?
Both. And I'm not arguing that she wasn't competent to stand trial. I think that, according to the court clinician's opinion, she was competent to stand trials, but she wasn't competent to represent herself without a guardian ad litem and an attorney to represent her. And so that's what I'm arguing, that the judge should have followed the advice and recommendation of the court clinician and not allowed mother to waive counsel, given her the deficits that the court clinician found that mother had with her reality testing, with her, what the judge got wrong is he concluded that because the court clinician said the mother would have difficulty representing herself and assisting counsel, and that he said any non-lawyer would have difficulty representing themselves at a termination trial. But that's not what the court clinician was saying. The court clinician was saying the mother had difficulties in perceiving facts, understanding and knowing what the proceeding was really about, what she was expected to do. And that is a very different thing than just an ordinary person attempting to do the job of a lawyer. And I'll say, too, that the competency to represent yourself at trial is a very different thing than competency to be a minimally fit mother, which was the second argument I made. So I hope that answers your question. Maybe not. You're right.
Well, you just touched on another issue that confuses me. How do we square the argument that mom was not competent to represent herself at trial with the claim that she yet was fit as a mother, or that she was not unfit as a mother? How can those both be true?
Because they're two different things. And what I would say is, it's the nexus argument, it's care and protection of Bruce. It is the mental health issue that might impede mother from conducting an adequate, any kind of defense at trial. The same as providing support, guidance, whatever, love, caring environment for the child. And I have to point out that the child's pediatrician, Dr. Cushman, reported that he can, quote, easily tell that mom loves and cares for her son. That he looks well when he comes to visit. And he gave no indication that despite, mother's eccentric behaviors, that the child was suffering in any way or losing out in any way as a result of her mental health issues. That's the point I was trying to make.
In considering whether the mother's waiver of counsel was valid, should we be considering the eccentricity, to use your word, of her trial strategy? In other words, after the judge ruled that the mother had waived counsel, the mother went on to a very lengthy trial, and she really fixated on the removal and on the alleged Native American heritage of the child. Are we to consider whether those were good arguments in determining whether or not her waiver of counsel was valid?
Well, I think it's corroboration of what her state of mind was at the time she waived the right. And there is a problem, too, because the judge issued his decision on the 10th, and 2 witnesses testified before the waiver of counsel form was executed on the 17th, I think, after mother's mother and the other pre-adoptive parent testified. Mother wasn't there because she had transportation problems, got there late after the witnesses started testifying. Then the judge held a colloquy, and then she executed the SJC waiver form, which I believe there wasn't an effective or valid waiver until that form was signed.
But on the 9th, she was present when the judge
on Zoom
made the finding
Right.
that she was.
Right. But so the question is, and the colloquy, by the way, showed Mother all over the place as to whether she was going to represent herself, she wasn't going to represent herself, whether she had to, she couldn't.
But on the issue of written waiver, this court has held in some instances you need a written waiver. For instance, waiving a right to a jury trial, there needs to be a written waiver.
Right. SJC Rule 310, I think.
And do you have a case for you need a written waiver for the waiver of counsel before trial?
I think it's Halterwanger. I think I cited it. And I know that that issue arose in adoption of Brianna, which was just decided, and the court in Brianna didn't reach that issue because they found the waiver in Brianna not to be voluntary, knowing, intelligent. So they didn't get to the issue whether, as to the timing of the execution of that waiver form. And I know he made an argument that that rule was amended, and that I do believe it is a requirement that that form be executed, and that the waiver is not valid unless and until it is. And in this case, Your Honor, the mother signed it, quote, under duress. Her signature says, I, woman, under duress.
We see that. The judge very clearly addressed that with her.
The judge asked her about it, but it was never corrected.
It was corrected. The judge addressed it with her directly and said, I will not accept this.
But the form still says.
Right, the form says it wasn't corrected, it wasn't sanitized, but the judge raised the issue with her directly.
Yep, he did.
Well, is the waiver what's on the form or what happens in court?
Well, the waiver isn't effective until it's signed by both the judge and the defendant. And it wasn't signed till after the trial had 2 witnesses testify.
What do we do with criminal cases like Robidoux? Back to your point about saying that the mother's subsequent strategy at trial is circumstantial evidence of the invalidity of her waiver of counsel, where in Robidoux, the defendant was found to be competent and he waived trial and he represented himself, and his defense was, God told me not to feed my child until the child died. And he was competent. That was the defense he chose to pursue. How is it that we're to consider the mother's fixation on the removal and the Native American heritage as showing?
What I'm saying is it's corroboration of her state of mind at the time she executed or agreed to the waiver and executed the form, for that matter. That's the time period that's relevant. I think the evidence of how she conducted, I think her, I would say, incompetence to represent herself is one of the reasons why this went on for 40 days of trial. One of them, which was I've never unheard of.
Anything further?
No, thank you. I'm sorry.
Your time is up, so thank you for your argument.
Okay, thank you, Your
We'll
Honor.
hear from from DCF and the child. Mr. Cuttle.
Good morning, Your Honors. Judge Sachs, can you please let me know when I have a minute to go on my time?
Yes, will do.
Your Honor, before I get into the waiver argument, William Cuttle for the Department of Children and Families.
Could I just stop you, I'm sorry, Mr. Cuttle, and ask our clerk to set the, okay, thank you. Just resetting the clock.
Okay.
We're good now.
So William Cuttle for the Department of Children and Families. Before I get into the waiver issue, I just want to remind this court that the trial judge made 450 findings of fact, 42, I believe, conclusions of law that were unchallenged by the mother in this case. The department's view is that this child would be in imminent harm if returned to the mother's care. That there's overwhelming evidence of her unfitness, her living a dangerous lifestyle, putting the child at risk in many circumstances, her home instability, her unwillingness or incapacity to deal with her own issues.
Her mental health issues as well.
Her mental health issues. She wasn't able to, we tried to have her do a psychological evaluation, a part-time hospitalization to address these issues. She just refused to do it.
But all those findings come after a trial where she essentially attempted to represent herself with some assistance from standby counsel, and the validity of that is what's at issue. So no matter how detailed the findings, if
Yes, you're right,
okay.
Your Honor.
So maybe you could address that.
And getting to the waivers, just to answer your question, Judge Sachs, directly, adoption of Williams sets out the standard for the voluntary, unequivocal, knowing, and intelligent waiver. Judge Smith, your question about the hearing that happened on the 7th, 8th, and 9th, that was not a true competency hearing. Mother, there was a colloquy that took an extra amount of time because Mother, as her counsel said, often got off track. The judge did an incredibly thorough, painstakingly patient job in helping to address this issue with Mother. And on the 9th, the judge made the decision to allow counsel's motion to withdraw and for Mother to represent herself. The court did rely on the competency reports. I really would direct your attention to the memorandum that the court issued. I think it's on page 82 of the record appendix or close to that. He sets out all of his reasons why he allowed the motion. He went through all the standards. Mother, in this case, just to be very clear, Mother this was her 5th attorney. She had gotten 3 continuances before this on the eve of trial, getting new attorneys. At one point, Mother accepted getting a new attorney. By the time trial came on June 7th, Mother was adamant and said very clearly throughout the hearing on the 7th, 8th, and 9th that she wanted to represent herself. She said it in different ways, but she wanted to represent herself. Did she sound artful and completely appropriate all the time? No, but that's not the standard. The court asked her question after question. In his memorandum of law, he identifies the judicial guidelines that he followed.
Counsel, I just want to stop you. When I look at the transcript, I'm not sure how adamant I see it, and I refer to page.
Say that again?
I'm not sure how adamant it was. It seems to be a lot of doubt. The first time I believe she's asked, she responds, as page 4 of the transcript, I'm not wanting to, trust me. There are a number of statements in which she says, for instance, I denied asking my attorney to withdraw. I've not asked him to withdraw. I do not know how to represent myself. I don't wish to represent myself. Again, I don't know how to represent myself. The court clinician who did the preliminary or screening exam on the 7th included a statement from the mother that she didn't wish to represent herself, she didn't want to proceed pro se. So I'm summarizing, but I don't know if I agree with...
I don't remember seeing all that, Your Honor, and I trust your assessment of that and what you're saying to me. I was focusing on the transcript on June 8th and June 9th.
Well, let me ask you about that transcript.
And the colloquy on June 17th. I'm sorry. Go ahead.
Well, on June 7th, set for trial, and mother didn't appear.
Right.
And the attorney moved to withdraw. It wasn't the mother motioning for a new attorney, but the attorney moved to withdraw. And the judge, perhaps based on his history in the case and based on the motion, flagged that as something he wanted to involve the court clinician. So on the next day, actually that same day, the court clinician on the 7th did meet with the mother.
I believe that's correct.
And then on the 8th, they started the colloquy. And
Right.
my question is, by the end, it was a very lengthy, and I think there's a lot of back and forth as to whether or not she was, the judge, one moment, determined she was making a knowing voluntary waiver, and he concludes the hearing, one moment, I'm sorry, by saying, I haven't received a response yet. That's how the hearings conclude on the 8th. And he says the threshold issue has been raised about her competency. There's some more discussion. She says she invokes her ADA rights.
Yes.
She I think at that point, well, not at that point, a prior point, invoked the rape shield, but then they suspend.
Right.
And the next day, they start without her present, and the judge announced he's made a decision.
So there's a lobby conference, I believe, at the beginning on the 9th. I think that's what happened.
Without her being present, without the pro se party, and he announces he's made his decision. So is that
She wasn't a pro se party at that point, Your Honor. That was a lobby conference between the attorneys, and her attorney was present for the lobby conference. And the judge...
When he announces she's going to represent herself...
That's later on in that hearing. At the beginning of that hearing, he meets with the attorneys, including her attorney, and clarifies that her attorney is not asking for a competency hearing. And he said, no, he was not. And then they went on the record, and then the colloquy continued with mother being present, and that's when the court...
During this lobby conference, if that's what it was, I'm quoting from page 121 of the record appendix, from the court, she's going to be representing herself, and they make arrangements on how standby counsel will be supporting her.
Yes.
Is that troublesome?
Mr. Cuttle, I just want to warn you, you have 1 minute left.
Okay. No, I don't think that's troublesome. I think you have to be, and just to clarify very quickly, I want to make a correction that the department in our brief, we said that it's an abuse of discretion standard. I want to clarify that it is, you have a de novo review of this matter, but need to take substantial deference of what the trial court assessed the evidence to be. And the trial court took the information from the clinicians, his information from going back and forth with the mother in this case, and made his determination. I want to clarify quickly the Brianna case that mother's attorney refers to. It's not relevant to the case before you, Your Honor. In that case, first of all, it's a 23 decision. Second of all, in that case, there was not a full colloquy like there was in this case. And in that case, the mother wanted another attorney. She did not in this case. Finally, on the 17th, the trial did start with the mother and the stepfather testifying. Mother was already her attorney at that time. She had missed trial on the 16th, the day before. The court was not going to wait again for a continuance because he has to consider what's in the best interest of this child as well. And he did a second colloquy to be extra careful and sign the form. And I don't know of any case that is that specific about the timing of the form. In this case, it was a full colloquy. The judge did his findings, issued a memorandum, and he had the mother sign the form and clarify that she was not under duress in signing the form. I'll rest on our brief.
Okay. Thank you, Mr. Cuttle. We'll hear from Ms. Gallup.
Good morning. Julie Gallup on behalf of the child. The child is asking that this court affirm the judgment of the lower court terminating mother's parental rights, as she was competent to waive counsel. I believe in my brief in the statement of procedural history, I lay out sites in the transcript and the record appendix that identify issues that my brother raised with regard to the waiver of counsel form not being signed previously. That was due to the fact that the motion to withdraw hearing was held over Zoom. Presumably, nobody was physically present in the courthouse to execute that form. With regard to Justice Grant's question about whether the conduct of the trial could be circumstantial evidence for this court to look at regarding whether mother was competent, I would suggest that the court should look at mother's competency at the time of the motion to withdraw hearing as opposed to the entire trial, because that is what the trial judge did. And the trial, mother has a right to counsel, but she also has the constitutional right to personal autonomy. She had a case that she wanted to pursue that required her attorney to withdraw due to, disagreement in rules of professional conduct. I would suggest that mother was clear that in her desire to represent herself, she had a case that she wanted to put on. I don't recall the site in the record, but she made some statement that basically she wanted DCF to be held accountable, or that she kind of wanted to put on this case to demonstrate what had happened to her, and and that the judge explained in his memorandum what he relied on in finding that she was competent to waive counsel.
Well, is the concept competent to waive counsel, or is the issue knowing, intelligent, and voluntary waiver of counsel? So in other words, arguably no non-lawyer is as competent as a lawyer in trying a case. Is that the standard, competent to waive counsel?
Sorry, no. The standard is that a parent's waiver must be voluntary, unequivocal, knowing, and intelligent. That is the standard. And the judge identifies in his memorandum of decision allowing the attorney's motion to withdraw the information that he relies upon at Record Appendix 82, that she's been actively engaged in this defense of this petition. He references the competency that was, the evaluation that was performed at the 72-hour hearing by the other court clinician, which, and he credited that individual's opinion that mother had a understanding. She understood the roles of the individuals involved. She understood the court procedure. She had a rational understanding of the advantages and disadvantages of having a hearing versus waiving her right to a hearing. And he continued to credit that that individual's opinion, and that is at Record Appendix 78 to 79. None of the previous 5 attorneys that represented mother suggested that she did not understand the proceedings, or that she could, nor that she could not understand them. And none of these attorneys requested a competency evaluation. To respond to, I believe, Justice Smith's question with regard to whether any of those 3 motion hearing dates were a competency hearing, I would say no, because prior to allowing the attorney's motion to withdraw, he made it clear that he was not asking for that type of hearing. And again, that mother had the right, the constitutional right, to put on the case that she chose to put on.
Well, let me ask you, the judge, again, had a lot of experience with this matter. At the very initial appearance, he ordered her to be examined for hospitalization. In that examination, I don't have the name of the examiner, determined she didn't need to be involuntarily or hospitalized, and then that led to the first clinical evaluation. And the clinical evaluation mentioned how limited it was in time and scope, but it did mention she could validly waive her right to have a hearing. It did conclude that or offer a basis for that conclusion. But it did recommend further evaluation. The second evaluation, similarly, the doctor, I think Dr. Flood, in June, mentioned how this was over Zoom. This was a short period of time. She mentioned how limited it was. I mean, at some point, there's an obligation for the court to do a more in-depth evaluation of her functional ability, of her competence.
Certainly, but I don't believe that it was appropriate in this case, given the facts at hand. Dr. Flood's report suggested that mother would benefit from the assistance of a guardian ad litem to mediate her anxiety about the case and to help her put forward her best response to the petition, and that's at Record Appendix 77. So Dr. Flood's report herself did not say that mother needs this guardian ad litem to understand the proceedings, and it is to mediate the anxiety. My client is now, so he was 1 month short of 5 years old at the time of removal, and he is now 9 years old. He's been in the pre-adoptive home since prior to the trial, and this child deserves permanency. At some point, there's case law that says that we should just say enough. The parent has had enough time, and this child deserves to know, that this is where he's going to be. There was I don't know if I could keep talking, but thank you.
I think we're familiar with that concept in the law.
All right, great, thank you.
Thank you. All right, we'll take about a 15-minute break and come back for the final case.